On this episode of Money Matters with Jim Doyle, prepare your heirs, not your estate. Lawyers Christine Lowe, Eric Clavier, and seniors advocate Berta Lopera explore an unconventional estate perspective. Plan more, worry less. This is Money Matters with Jim Doyle.
Estate planning is just not about who gets your stuff. What a better outcome for your heirs? Today we'll be addressing the benefit of talking to your heirs about what to expect. Often overlooked, the rights, roles, and responsibilities of the various people you've asked to manage your affairs. From the power of attorney to the representation agreement or functioning as an executor, many people accept these roles with little understanding of what it truly entails. But first, I sent Paige to capture people's feeling about planning for when you're no longer here.
When it comes to managing an estate, what is the first thing that comes to mind?
Oh, children.
Protecting as much of the assets as possible for your heirs.
Financial security and how much money you've got in the bank. I think that's the first thing that comes to my mind.
The state of the family. Well, the first thing that comes to mind is how the hell they're going to survive in the future.
Things that come to my mind are like asset allocation, making sure all the parties, like family members, are in line with it, attorney fees, legal issues, going through red tapeism, worrying about estate taxes, capital gains taxes. So everybody wants a piece of the pie when there is free money involved.
The planning clients we work with share these same concerns. From looking after the children and protecting heirs to financial security and family dynamics, there's a lot to pay attention to. So Eric, what's your sense on people being prepared for this sort of stuff?
I would agree that most of the time people that are nominated as executors or attorneys don't necessarily know what the role entails. They might accept it without having been told what they really will have to do. And so it is important that there is some kind of conversation with the person nominating them ahead of time to ensure that they actually know what they're getting themselves into.
So Christine, we hear that people are a little bit uncomfortable talking about their mortality. How do we help them get beyond that?
Something that's very helpful is knowing that if you have a conversation earlier, it actually helps prepare things or prepare your family for when grief does come later on. So trying to have family meetings or conversations, just warming up to the idea often helps families.
Fair comment. We're going to be right back.
Sometimes you see seniors that have worked hard during their entire life and suddenly their assets disappear.
Welcome back. Estate planning is a large part of our planning practice. Now, how we like to describe it is the preparation of tasks that serve to manage your financial affairs in the event of incapacity or death. Now, as a lawyer, how do you help start these conversations?
We help guide our clients by framing the way they think of it. Are they thinking of it as a means to an end or a means to enable? So when they're thinking of passing their wealth to their children, what frame of mind are they looking at?
Now, a lot of families, they rely on the lawyers to tell them everything. Is that a great way to approach this?
I would say no. I think that you have to have an idea of what you want. The lawyer is there to advise you of your options and to give guidance as to the most efficient way of getting you there. But at the same time, you should have an idea before you go to the lawyer as to how you want to devise your assets and how you want to do your estate planning so that the lawyer can take you by the hand and show you how to get there.
So don't keep secrets when you're talking to your lawyer. Let them know what's going on in your family. Does that sound important?
Absolutely. We need to know their heartbeat, where they're coming from, what they actually want. And then from there, we, kind of figure out what the law is and see how it can work together.
Christine, I see a lot of families wrestle with these same issues. I met up with Berta Lopera, Executive Director of Seniors First BC, to talk about the darker side of the power of attorney. So, as Executive Director of Seniors First BC, are you surprised with the number of issues you see regarding power of attorney?
Yes, there have been lots of complaints because in many cases people misuse the power of attorney by misappropriating the funds and transferring assets for their own benefit.
So I'm hearing hurt families, missed expectations, and problems for the lives of those that we're trying to care for.
Absolutely. So, and that is what hurts the most because sometimes you see seniors that have worked hard during their entire life and suddenly their assets disappear. The worst is with people that they trusted, right?
That sounds like broken trust.
That sounds exactly, and that is what it is, broken trust.
Now, based on what we've just heard, can we talk about the things that you can do with the power of attorney and maybe the things that you can't do with it? Christine, how'd you like to start us?
So starting with the can, what you can do is a power of attorney allows you to appoint another friend, family member, someone that you trust to handle your financial affairs as if they were you. It means whether you're traveling and capable or incapable in case of an accident.
Now, stepping into those shoes, talking about things that you can't do.
Most important thing that you cannot do is you cannot take money that belongs to the person who gave you the power of attorney and use it for your own personal benefit. You have to act at all times with the best interests of that person in mind. You're not allowed to take a fee for what you do unless the power of attorney specifically stipulates. And you're also not allowed to gift yourself any money or any items because that falls outside of your purview and you're in a fiduciary role. So you have to at all times act with an abundance of honesty.
Now, I've heard people say, listen, I'm going to inherit it anyways. Why can't I take this money and use it for myself?
We hear that often, but of course, the time's not now. So it's very important to know what your duty is as an attorney, that's the person appointed, to use the funds for the best interest of the person who gave you that power.
So we want to make sure that you're using it in the right way. Are you clear on what the role of the power of attorney is and what an executor does? We sent Paige to ask.
Are you familiar with what the role of a power of attorney or an executor requires?
Yeah, it's well, of course, in England, I don't know what the Canadian laws are, but I guess they wouldn't be that much different. Is the fact that you take over the running of the finances for your parent or parents.
It's just that if I give a power of attorney to her, it just means that for all legal purposes, she can execute her signature and it'll be as good as mine.
I have had power of attorney in the past over my mother's estate, and I was the executor as well, so yes, I know both those.
Tell us a bit about your experience.
It was fairly easy. We were a nuclear family, so there weren't many recipients, there weren't many beneficiaries, so it was fairly straightforward, but I did it all myself and it was fairly easy.
Now, would it be fair to say that most of us have a good handle on the role of the executor and of the power of attorney?
I would actually say no. I think that at a high level overview, people understand what to do, but for the day-to-day banking or real estate, I don't think that they're prepared yet to know what to do.
Now, Eric, you probably see a lot of this in your world as a litigator, people not being prepared. What does that look like?
Well, it can end up being quite bad for them because as the attorney, you owe a duty to account to the adult, and if the adult happens to pass away, to the estate of that adult who can require you to provide an accounting for what you've done as the attorney. And if you didn't know that you have to keep proper records or that you have to keep meticulous backup documents in order to prove how you spent that adult's funds, then you might end up in a position where you have to pay money back to the estate simply because you don't have the documentation to prove that you acted in the best interests of the adult while as attorney.
So Christine, what tips would you offer for being better prepared to serve in this role?
So there's a couple of things that you can do. The person who's granting it, they can let their chosen attorneys know, this is the type of health care that I want. I want in-home care versus going to a nursing home. This is what I would like to prioritize. Clients can also write a letter of wishes to describe what's important to them, to give a little bit of a guideline to the people that they appoint.
Now, you just talked about something called the representation agreement. What is that again?
It's essentially a power of attorney, but for healthcare. You can appoint someone to make healthcare decisions for you when you lose capacity.
So somebody to look after your money and somebody to help you with your healthcare choices. We'll be right back.
I just think what we decide to leave, we make the decisions, they've got to live with it.
Welcome back. Many people are surprised to discover they've been appointed on an enduring power of attorney or as an executor, sometimes with disastrous consequences.
I think that's fair because a lot of people nominate an executor in their will without having actually discussed with that person whether or not he or she is prepared to take on that role. And so they're thrust into this upon the death of the deceased, and they don't necessarily know what they're supposed to be doing. They don't necessarily want to assume that role. And that can lead to difficulties because if the parent didn't leave an alternate executor, for example, then who takes over the management of that estate or the administration of that estate? So it's important for whoever you nominate as your attorney or as your executor to not only know about it, but to be prepared to assume that role.
I like the idea of being prepared, Christine. We talk about the skills that are necessary for the roles. Do people give that much thought?
So no, they don't. It's very important to know that you don't have to know everything. You can hire legal help from an accountant, a financial advisor, but you do need to be honest and trustworthy, and you shouldn't be afraid of being organized. Those are skills that you'll need because an estate can take anywhere from 1 to 3 years to administer.
Let's go to Paige as she asks a chicken and egg question.
Should heirs be involved in the estate planning process?
Yes, I think so. Else how do they know what's supposed to happen? And they're supposed to know what the outcome is supposed to be and what the aim of the estate planning is. So they should know it, so they know that the outcome is what is expected, basically.
Oh, it's a difficult question. Maybe, maybe not. Depends on your family situation.
I just think what we decide to leave, we make the decisions, they've got to live with it.
At least from my friends who lost their, beloved ones, they did struggle big time after they didn't know lots of legal issues. They didn't know where to find the will. They have to be involved. So it's like my advice: sit down and have a talk with your folks.
As we've heard, heirs can be saddled with additional obligations, administering an estate with little preparation in the rights, roles, duties, and responsibilities of the role. Why can this be a problem?
Simply because they don't know what's coming down the pike. Also because there can be animosity or irritation between siblings if one person becomes the executor and the other one doesn't, or that person who is nominated is not trusted by the other heirs. So I agree with the one lady, Sheila, I think her name was, that it kind of depends on the family. You have to have a case-specific analysis as to whether or not you want to involve your heirs in the estate planning process, because really in some families that will work, in others it certainly wouldn't.
Now we work with a number of family businesses where, the business needs to continue. Want to talk about that role a little bit?
Yes, so it's not uncommon to see one child, say the daughter, working with her parents or her dad in the family business. And when it comes time to dividing the wealth or when they're doing the succession plan, the parent might want to give that company to that daughter. It might mean that she's getting more than her siblings. So it's important to at least discuss at a high level what the plan is and the reasons behind it.
We're just trying to make sense of this sort of stuff. So let's go back to Berta as she talks about the complex responsibilities of being an executor. So why do you think it's important to put some thought into choosing your executor?
Well, first I will tell you what an executor is. The executor is a person appointed in the will who is in charge of following the instructions written in the will.
Now I know in my world, sometimes I hear families going, you know what, I just discovered I've been appointed to the role at the reading of the will.
Well, because families don't talk about these issues, and I think it is very much time to talk about these sensitive issues, because that lack of communication destroys families and creates acrimony amongst siblings.
Now, some families traditionally appoint the eldest child. Is that a good thing to do?
If that person has the skills, that is a very good thing. But sometimes it's not the person with the best skills for the job.
So what type of skills are we talking about?
Running a business, dealing with money, having patience, right? And having the time.
So if you're not a tax and math numbers person, this might be a tough job?
Not necessarily, because for that reason there are accountants, there are lawyers, right? But the most important part is you have to be willing to act and put the time, the patience, and cope with the beneficiaries. That sometimes it is a difficult job, trust me.
Now, two items caught my attention here. One was managing beneficiary expectations, and the other was the skills that an executor needs.
With respect to the beneficiary expectations, oftentimes children or people who inherit don't understand the length of time it takes to administer an estate. It can be anywhere between 1 to 3 years. There's also a lot of expenses during that time. The deceased might have had debts or mortgages that they had to pay off, so what they end up receiving, the beneficiaries, is smaller than what they might expect.
Now, Eric, we've seen, a lot of folks come to us, they saw a big number on a will, and then they get way less than that, and the trust is damaged.
So the most important thing to tack on is the communication aspect, or to keep managing the expectations. You have to be open with the beneficiaries, let them know where things are at, and you have to be completely transparent. So if they have questions and you think that these are questions that are valid, that require an answer, you should deal with them, and deal with them on an ongoing basis, because the last thing you want is to lose the trust of a beneficiary. They may then get to a point where they don't want you to remain on as executor, and you're precluded from doing your work because there's court cases. You mentioned that it might take between 1 and 3 years to manage an estate. While that is generally speaking true, if there's litigation involved, it can take even longer. So I think that the main important thing that an executor should always remember is keep the heirs appraised of what's going on.
Eric, I love what you said there. Keep the heirs in the loop. We'll be right back.
It is their money, their independency, and their financial security.
Welcome back. We've been talking about an unconventional estate perspective. Prepare your heirs, not your estate. I want to get my panelists' final thoughts on today's subject. Eric?
The first thing I would say is when you decide on a POA or you decide on an executor, think it through very carefully, because if there's acrimony between your children, or if you foresee that there might be, you may not want to go with a family member because it can end up leading to disaster down the road. They may end up fighting, or it may end up being an ugly situation that involves court proceedings. So that's not in anyone's best interest. So be careful who you select, think it through, make sure, and this is the second point, it is someone you trust completely. This has got to be somebody that you have complete faith in, because at the end of the day, they have to put your best interests first, and they have to execute your wishes if we're talking about the executor.
I got a quick question for you here. What's the primary cause of estate litigation?
Generally speaking, it would be a will's variation. Someone's been excluded from the will and they would want to have their slice of the pie, so they might sue on that basis. But it could be anything. It could also be that somebody doesn't trust what the executor is doing, or thinks the executor is being underhanded and taking assets from the estate and not fulfilling the mandate under the will. So anything possible under the sky, quite frankly.
Eric, some great thoughts there. I want to go back to Berta to hear what she has to say. So I'd love to hear your final thoughts on what we've been talking about today.
Yeah, first of all, that is very important to have that uncomfortable conversation in the families, so to facilitate things, so everybody knows what they have to do and why are they appointed in the will.
Don't let it be a surprise.
Exactly. I mean, and hopefully they seek independent legal advice and to see what they can do and what they cannot do.
Now, I know there's another tricky element you want to talk to us about.
Oh, yes, because it is very much asked for, and it's joint ownership. bank accounts, joint bank accounts, that may create problems. So first of all, you have to know why you want to do this. It's because I want to give a gift to this person when I pass away, or because it is just for convenience. After all, so a person should have in mind it is their money, their independency, and their financial security, and you should do it now.
Honoring their wishes. What great advice. Now, Christine, I'd love to hear your final thoughts on today's subject.
When I think back about what we talked about today, I can sum it up as the 3 T's. The first one is when you're thinking of who to appoint as your attorney under your power of attorney or as your executor, you want somebody that you trust, somebody who has time on their side, so someone who wants to do it but also has the time to do it. And last, travel, someone who doesn't have to travel too far. Sometimes you pick family members that have to come a far ways. It's oftentimes best if you can have somebody who's here.
Christine, I love where you went with this. I want to share a couple of personal perspectives on this subject if I can. You know, people rarely consider the legacy that their estate planning wishes leave with their family. Help your executor manage beneficiary expectations and prepare those involved in the administration of your estate with the rights, roles, and responsibilities. Now, for more ideas, follow me on Twitter at @JDoyleVancouver. Now, I want to thank Christine, Berta, and Eric for their thoughts here today on Money Matters. Because financial aspects touch so many elements of our lives, it pays to get great advice. Plan more, worry less.